you for accommodating us, Ms. Burns.
Of course. Okay, so rehabilitation criteria. So this one is for rehabilitation criteria. A is when we're talking about a applicant or a person who's being reinstated, so their license has already been revoked. And this A is the part for if they completed their sentence and their probation or parole without any violations. And therefore, A is the consider whether they have rehabilitated with these criteria. So let me step back. So right now, you do rehabilitation. There's all of the petition you guys hear at the petition. There's that packet, right? And they make a showing of rehabilitation. And that is the board's criteria for rehabilitation. This 2138 says that you have to consider whether someone is rehabilitated by like one option is they've completed their sentence and have not violated probation or parole, or you've met the board's criteria. So since that law says consider whether, this is the two options. Option one says that we're going to consider whether you've rehabilitated either by by finishing your sentence and probation or parole without any violation, and consider the criteria in here, which is nature and severity of the act, the reasons for granting the length of parole, the extent to which the applicable parole or probation was shortened or lengthened, and for what reasons, the terms or conditions of parole and the extent to which they bear on the applicant or petitioner's rehabilitation, and the extent to which the terms or conditions of parole or probation were modified, and the reasons for that modification. So these are the criteria if you completed without any violations. Say you did violate or there was no probation or parole involved, then you would be under B. So this is the consider whether. We'll consider A, and then you have all that evidence to see if you have. Or if A is not applicable, you go down to B, and then you have to provide all of this, where evidence of any acts committed, where did it go? So the extent to which the applicant complied with any terms of parole, the extent of the criteria in A, and then any evidence of rehabilitation. And this is where we've taken some of the language that you guys asked for in a petition, demonstrating that the applicant or petitioner has a mature, measured appreciation of the gravity of the misconduct and remorse for the harm caused. Evidence should also show a demonstrated course of conduct by the applicant or petitioner that convinces and assures the board that the public will be safe if the person is permitted to be licensed or registered to practice psychology. So some of this is taken from the petitions that you ask now and kind of putting it into the regulations that this is what the board's criteria is for rehabilitation. So option 2, on the other hand, if you look at option 2 on the next page, option 2 is more of the automatic, you have rehabilitated if you have finished your conviction, if you've finished your sentence and probation without any violations of probation or parole. If you have done that, you're already rehabilitated. No need to go to section B. So essentially, by finishing your sentence without a violation of probation or parole, you are technically rehabilitated and you would therefore be given reinstatement. Unless, of course, you didn't have any of that and you fell into category B. So if you violated parole or whatever your crime or act was, did not have a sentence and probation or parole. So option 1 says, if you did everything without any violations, we still want to consider these 5 criteria. And if those don't apply, you go down to B, which is our own measured. Option 2 more says, if you completed without a violation of probation or parole, you're rehabilitated, hand you back your license. Or let's hand you the license. So that's kind of the very overall idea of option 1 versus 2. Option 1, consider all these criteria, espouse the board's criteria in there. Option 2, more automated. So if you meet A, done. So those are your two different options there. And then for suspensions and revocations,
Can I suggest maybe we stick with just the denials and reinstatements first before we go on to that? I think
Go for it.
because I think the discussion will
that's true.
helpful if we for the next section. And I just want to apologize on when you're looking at either option, actually, in sub B, where you have language that's both underlined and crossed out. I believe that was my doing. I think there was some language that came from some suggested language from our office, which was underlined, but then I crossed it out because I was rewording it. So it's meant to be struck through, it should probably not be there.
Are there any questions for Ms. Burns?
Oh, sorry. And staff recommends option 1. I don't think I said that at any point in time.
Yeah, that gives me an easy question. Why does staff recommend option number 1?
I think it's because you like how I'm like, I think. Staff would like to make sure that even if you have completed your violation or completed your sentence without a violation of probation or parole, that we're looking deeper into those things, whether it's not just your probation could be cut short because of prison population issues, not because you've done an excellent job and really done all of the work to rehabilitate yourself. So, I mean, there's a variety of different ways in which these things can happen, and we would like to have all of the information to look at to really assess rehabilitation. So the automatic rehabilitation just kind of cuts that short for potentially arbitrary reasons. You know, these could be state reasons why your probation or parole is done sooner and it's shorter.
Well, the thing that strikes me about it is we're saying these crimes are relevant to the qualifications, or the facts underlying the crimes are relevant to the qualifications for being licensed or registered or whatever. I think for us to say, but if you got through it on parole, it's okay. So somebody could do all those things, but it's still that underlying behavior may still be relevant to whether it's safe for consumers to have a licensed professional that has got that kind of background. So I think we would want to dig deeper. We're not trying to defeat the intent of the legislation, but we want to make sure that the public is safe. And obviously we've been given room to make regulations about this. So I'd rather that we do it in a way that maximizes protection to consumers.
I agree. I think it's exactly like the first piece that we considered. I mean, the more that we can really focus on the kinds of criteria that are important for psychology licensure, the better, you know, the more helpful it is.
So right now we're talking about option 1 on substantial relationship criteria. Is that correct?
I think right now we're on option 1 of rehabilitation criteria.
On rehabilitation. Okay. Are we going back to the other?
Did we discuss the other?
I don't think you've discussed either. I think we've just gotten my summary of these.
Oh, sorry.
We haven't had a motion, but
But I thought we
No.
were to discuss. Wasn't that your suggestion, or am I wrong?
I actually thought that was Ms. Stark's suggestion. I don't think I was
So
repeating it. I think what I was saying is even if you discuss them separately, you'll have one package.
Mhm.
Right?
Yeah.
So would it make sense then for us to discuss the first one and then just move through?
That would help me.
That would make a lot of sense.
So we're going to turn to the substantial relationship criteria regulations, which is page 1 and 2 of the proposed language. This is in relation to 1394, section 1394.
Can I say something?
Yes.
So I had a couple of thoughts. One is when we specify, could we possibly be missing something? Does it limit us in that way? And the other, when we talk about in number 8, conviction or act involving harassment, trespass, or stalking, so often whatever act has happened gets reduced to a trespass, and then it's a misdemeanor. And would we really be so does this state that if somebody was convicted of a trespass and gets this misdemeanor, they automatically are not eligible? Is that how that would be written?
I don't believe it's automatic ever. I think what we do is we take a look at the crimes that were committed, and then you go back up to B, where you have to consider the nature and gravity of the offense, the number of years elapsed, and the nature and duties, if I'm not mistaken. Is that?
And I want to sort of quickly draw attention to the distinction between eligible for licensure, which means that you've met the minimum qualifications for licensure, versus fitness for licensure. So what this is a description of what may or may not make you fit for licensure. And I think what this does is categorize certain acts which the board would be saying, we think these kinds of acts operate to make you not fit for licensure. Now, it's always going to be case by case. The board will always have its prosecutorial discretion whether to move forward because there's a conviction or act for trespassing because somebody was protesting
That was my worry. That was my worry.
Yeah, a Walmart or something like
Yeah.
that versus
Yeah.
something that you may be referring to, which was someone coming in looking in someone's bathroom window, which then may be
We
led
did.
to a trespass rather than something
Yeah.
else. So it always gives the board the option to look at those acts.
I think also to the point that you originally brought up at the very beginning of what you're speaking about, that it says including but not limited to.
I answered my question
Yeah,
when
yeah,
I
yeah.
looked at that. Yeah.
Okay.
But okay. So that's helpful. Thank you.
And I would generally say there is quite a difference between having a long and exhaustive list that does kind of indicate, hey, if there's anything past these 25 or whatever, then you're getting somewhere. So we've tried to keep this very short so that it's not hinting at it. This is an exhaustive list. Yeah.
Are there any questions or comments related to the language for 1394? So, Ms. Marks, would you prefer to have a motion to approve each language as we go along and then one motion to submit the language if they're all approved? Or would you like to do just two motions, one to adopt one of the options and then one to submit? What's your preference?
I'm not sure I really have a preference. I think what the board would be doing is still one regulatory package. Doing two motions, however, will avoid trying to do a mix and match of the separate sections, whereas, well, some people like option one on one and option two on the other, but then what happens if some people like option two on one and option one on the other? So two motions would at least clarify which option you're going for with each section, and then you'd have one motion to initiate the rulemaking with those particular preferences.
Perfect. So, with Ms. Jones? No. So for this first section, would there be a motion to adopt one of the options? I'm adopting cats and dogs apparently in doing this. Is there a motion to approve language for one of the options, and staff's recommendation is to approve option one?
Second.
So we have a motion from Dr. Tate and a second from Dr. Harb Sheets relating to approving language for option one for section 1394. Is there board comment or discussion? Dr. Horn? Public comment? Additional comments? Mr. Glass-Beagle?
Quabadu? Kasuga?
Aye.
Horn?
Aye.
Sorry, Fu?
Aye.
Horn?
Aye.
Jones?
Aye.
Phillips?
Aye.
Harb Sheets?
Aye.
Aye.
Motion passes.
So on to the second item, which is the rehabilitation criteria for denials and reinstatement regulations. This is page 3 and 4 related to section 1395. And again, there's option 1 and option 2 before you. And option 1 is the staff recommendation. Dr. Kasuga? Oh, I heard a click, so I thought it was.
Ready for a motion?
Is there,
You're going to make it.
is there a motion?
I move to adopt option 1 on rehabilitation criteria for denials and reinstatements.
So we have a motion from Dr. Kasuga and a second from Ms. Akwebudu to approve language for option 1 related to section 1395. Is there board discussion and board comment? Is there public comment? All right, seeing and hearing none, Mr. Glassbeagle, could you please call the roll?
Quabadu.
Aye.
Kasuga.
Aye.
Fu.
Aye.
Horn.
Aye.
Jones.
Aye.
Phillips.
Aye.
Arbsheets.
Aye.
Date.
Aye.
Motion passes.
All right. And there's a third section, this time no options, but there is proposed language. So there's no options, but there's proposed language related to the rehabilitation criteria for suspensions or revocations and disciplinary guidelines and uniform standards related to substance abuse, abusing licensees, also known as page 5, 1395.1 on the last page, and point 2.
Mr. Fu, if I could just throw out there, the board, of course, always has options, but I think the reason why there are no options offered by staff with respect to this particular section is because 2138 is meant to apply to applicants, initial applicants for licensure, making it easier for them, whereas 1395.1 are the rehab criteria for licensees. So 2138 is not was not meant to make it more difficult for licensees. Or, I mean, sorry, was not meant to make it more, remove the obstacles as it does for applicants.
I don't think, Ms. Burns, you had an opportunity to present on this one.
No.
Would you like to? So
You can, it just conforms with the ones above. So this is just putting these rehabilitation criteria into there. I think this makes it very clear what the rehabilitation criteria is. We're also looking at some of the same things. So, you know, the reason for granting the probation, length of the probation or parole, the extent to which the applicable parole was shortened, and for why. So this keeps us somewhat consistent when we're looking at rehabilitation criteria. As soon as you're going to move one, you might want to look at the other. So this gives you those. And then, of course, it does put in those wonderful parts about remorse and for the harm caused and the things that you're already looking to hear from licensees. So,
are there any questions for Ms. Burns and the presentation?
The only thing that I would point out right now, and possibly this is a question for Mr. Tom Play, is I suggested changing the first line to, instead of considering the suspension or revocation, to considering the discipline. However, it occurs to me that suspension or revocation may well refer to an ISO, which isn't discipline. Would you consider it discipline? So my concern is taking discipline out. No, because really with an ISO, you wouldn't even be talking about rehab.
Why?
So,
Yeah, plain English for ISO, just so we're all
I'm sorry,
up to
interim
speed.
suspension order. I'm sorry, Mr. Tom Play. If that's what it was meant to refer to, because we do use it with the substantial relationship criteria, which I think it would be very relevant when you're talking about an interim suspension order, but with rehab criteria, I'm not sure it's really relevant. So maybe we do just need to refer to discipline as opposed to suspension or revocation.
Yeah, when the board issues a interim suspension order, that's done by an ALJ. The board delegates that to an administrative law judge, And there's separate criteria in the government code that speaks to that. And that's just about a matter of an imminent threat to the public. So you don't need to include ISO
So
here.
if that's what suspension was supposed to refer to, then I don't know that it's
No, this refers to suspension as a separate discipline. Like
Right.
someone commits an extreme departure from the standard of care. We issue them 5 years of probation, and as an added penalty, sometimes there'll be a 60-day suspension of their license. So it's that discrete suspension that this is speaking to, I think.
So would you then agree that we could just refer to discipline instead of suspension or revocation there
Sure.
in that particular section?
I don't have a big picture. I'd like to read the sections before and after this before I can answer your question. Discipline includes those things, but why does this section specifically say only suspension and revocation and not probation? I'm not sure.
Right. I initially was thinking maybe it would refer to restriction or revocation. However, when I look at the substantial relationship criteria section, I think there where you're talking about suspension with respect to potentially an interim suspension order, then I think substantial relationship, it's very relevant, right? Because you're going to go in and you're going to argue that whatever crime was committed or act was committed is substantially related and therefore justifies the suspension, the interim suspension of that license, right?
Sure.
But with rehab criteria, if it has the same meaning, I don't think it's relevant. If we're talking about restriction versus revocation, then I think we would use that term. But then we'd want to go back and look at substantial relationship criteria and use suspension, restriction, or revocation. When I think about revocation, I don't necessarily think that it means just straight up revocation. It could be revocation stayed.
Yeah, that makes sense.
That's why I think we can just refer to discipline.
Sure.
Because I don't think rehab criteria is relevant when you're going in for an suspension order. So yeah, then we would want to try and change that as well. But yeah.
Sure.
So
that makes sense.
I'm
just a bigger picture point. I don't want to throw a monkey wrench in this, but as I'm thinking about this now, there's no obligation under 2138 to change any of this section. Does that sound fair? This section, so 2138 takes discretion from the board to discipline or deny licenses, but it doesn't change the board's discretion to determine how it wants to reinstate a licensee, for example. And I don't know if the board's already considered this, but another option would be not to change anything because we already have regulations in place that don't need to be changed, at least as for that type of licensee. So to the extent when you mirror this language from 2138, you're conceding that, let's also restrict our discretion in this area where we don't have to. So just another option.
Look at that.
You just got another option.
What was the original reasoning for changing this section?
Part of it is because the bill requires us to add to the rehabilitation criteria to consider whether an applicant or licensee that's completed their criminal sentence at issue without a violation of probation or parole is rehabilitated. So we had to kind of like insert that in, which is kind of required us to open things up. And then trying to kind of look at the spirit of the law and what we're doing and inserting in those nature and gravity years elapsed considerations. So just trying to integrate all those in there. Yeah.
Well,
Actually, you don't have to mirror. I mean,
actually 2138 does require the board to develop criteria to evaluate rehabilitation, both when considering the denial or considering the suspension or revocation.
that's for both.
So, and
Only one part of it.
then you consider whether they've made a showing of rehabilitation if they've completed their criminal sentence without a violation of parole or probation. So it does actually require both. They use suspension or revocation. I'm not sure whether that's supposed to refer to an interim suspension or just one of the restrictions that you can be applied when you discipline a license. I'm not entirely sure.
Some boards use just one set of rehabilitation criteria in general, and they don't have two separate ones for different categories. So that might also be the consideration here, is the law was written to tell you to put certain things in your rehabilitation criteria, and some boards have all right rehabilitation criteria in one, and some have it in separate spots for denials and reinstatements, and suspension and revocations. So, man, I'm like, which one and which category? And then obviously, anytime you're going to open this up, obviously adding in our actual rehabilitation criteria that, you know, the board considers important, that the board members ask questions about. I mean, we have these petition hearings and we hear the deliberative questions, so these are kind of meant to go in with that. So, which is the part in B, that B7.
So I think just to recap this discussion, the proposed changes by staff related to 1395.1 and .2 are required by Assembly Bill 2138, and so that's why we're considering them before us. And Ms. Mark's question to Mr. Tom Clay was related to interim suspension orders, and so I'm not sure that has been resolved.
I'll try to answer my part, and then Ms. Marks, maybe you can draft the appropriate language. So an interim suspension order, I think, is a separate type of thing from a standard disciplinary order. It's got its own rules, and I think there's a good argument that it's not discipline per se. It's this interim public protection measure until we get to that disciplinary hearing and decision. So I would treat it separately, particularly since I just don't think we want to burden that critical process with this complicated set of criteria if we don't have to. I don't think we have to. Just my gut instinct from what an ISO means versus what discipline is.
Yeah, I think as best I can come up with the current language in 482, which is the rehab criteria section, refers to developing criteria for rehabilitation when considering either the denial or the suspension or revocation under Section 290. It is not clear to me whether that refers to an interim suspension order, which is separate, because I think a revocation would include all of those disciplinary terms up to and including unstayed revocation. As I said, with substantial relationship, I think it's very relevant for suspension as interim suspension order, as well as any other disciplinary action. I don't necessarily see it as relevant with rehab, or rehab criteria relevant with an interim suspension order, because it's very immediate. You're not usually looking, or you would know better than I, because you're the one who's going in and asking the ALJ for an interim suspension order. I don't think you'd be getting into rehab criteria discussion.
I don't think. I think there's separate criteria. They're similar,
right?
But yeah, they're not the same thing. I don't think.
I mean, would you really be talking about rehab at that point?
Well, you'd only be talking about rehab if the reason we want to suspend someone is they just committed a crime, and were just convicted of a crime. It doesn't really work, does it? In practice, I'm not sure this makes a big difference, but I do think they're different.
You're on.
If I'm understanding correctly, interim suspension order is an entirely different beast that we do not have to concern ourselves with relative to this discussion. I think that's what you're both saying, if I understand correctly.
That's how normally I would think of it. The statute, however, does refer to suspension or revocation, and I think then the language of the regulation can refer to that in the initial statement of reasons. Make sure it's clear that when we talk about revocation, we are talking about all of those restrictions that may go up to an unstayed revocation. So as opposed to suspension somehow being a term that refers to something less than revocation, if that makes any sense. And I think that's where we address it. Instead of changing the language as I've suggested, use the language of the statute of suspension and revocation, but then describe in the ISR what the board means, which is the revocation means any discipline, any restriction leading up to revocation. Does that make sense?
That makes sense to me. So it sounds like we would just stick with the suspension or revocation language. It speaks for itself.
Right.
Okay.
Right. And then, you know, while I don't necessarily see rehab criteria as relevant for an interim suspension order, perhaps it is. When it's being litigated, I don't know. Because as you say, it's very immediate. You're not looking at the bigger picture usually, right, with an ISO.
If this were to read suspension or revocation, I wouldn't be confused as a prosecutor reading this. So, yeah.
Is that a satisfactory nod, Ms. Marks?
Yeah, no, I think we use the language of the statute, and then, as I said, in the ISR, talk about revocation, meaning the whole realm, the whole arc of the restrictions that can lead up to an unstayed revocation.
So unstrike and get rid of discipline and unstrike suspension.
Right. Stick with the original language.
So the change that we're on that first line right under 1395.1, we're saying when considering the suspension or revocation, which is the original language, and we're not using discipline. So that's the change that I think we're asking for. So would there be a motion to approve the language as amended relation to 1395.1 and 1395.2? Oh, sorry.
Before you go on, Mr. Fu, I then want to correct what I said earlier about why you may only have one option here. I think you would still have the other options as you had with 1395, which is to say that the board could have language that says that a licensee is considered rehabilitated if he or she has completed the criminal sentence without a violation of probation or parole. You could potentially have that option.
If you wanted to. You could have an option 2 to 1395.1 is what she's saying.
Got it.
That mirrors 1395.
So we don't have a hypothetical option 2 in front of us. So I think what I would suggest is that we go ahead and look at the language in front of us, and if we don't like it, we can consider the hypothetical option 2 in more detail. So is there a motion to approve the language as amended with relation to 1395.1 and 1395.2? Moved by Dr. Tate and seconded by Dr. Harpsheets. Is there any board discussion?
I do have a question. So with that hypothetical option 2, is staff making a recommendation to go with what's here or to explore that option 2?
Board staff would like to consider option 1 as the recommended staff option.
Thank you.
Any other board discussion or questions? Any public comment? Mr. Glasspiegel?
Aquibadu. Kasuga.
Aye.
Fu.
Aye.
Horn.
Aye.
Jones.
Aye.
Phillips.
Aye.
Harpsheets.
Aye.
Tate.
Aye.
Motion passes.
All right, and we're not done yet with this item. So would there be a motion to start the formal rulemaking process, set for hearing, and delegate to staff to make non-substantive changes in the rulemaking file with relation to the approved languages for option 1 in all of the sections that we've discussed? 1394, 1395, 1395.1, and 1395.2.
So move.
Moved by Dr. Kasuga and seconded by Ms. Aquibadu. Any board discussion? Any public comment? Oh, Dr. Horn?
Getting ready to say aye.
I can see the lights go on, so I just want to make sure. Get ahead of the game. Any public comment? All right, seeing and hearing no board discussion, staff, or public comment. Mr. Glass-Steagall, could you please call the roll?
Quabadu.
Aye.
Kasuga.
Aye.
Fu.
Aye.
Horn.
Aye.
Jones.
Aye.
Phillips.
Aye.
Arbsheets.
Aye.
Tate.
Aye.
Motion passes.
All right, Dr. Phillips.
Thank you very much, Mr. Fu. Yeah.
Yesterday at the board meeting and during the DCA executive update, the board was given some props for our hard work on this bill implementation. And I just want to give a shout out to Ms. Burns, Ms. Monterubio, Ms. Chung, Ms. Marks, and Mr. Glass-Steagall for all their hard work, the enforcement unit for looking at the language, but most of all, Ms. Burns for her hard work on this issue. So I just want to give props where props are due.
Okay, we're now going to move on to agenda item number 18, or move back to agenda item 18, I should say, which is the outreach and education update. Ms. Burnell had to leave a little early today, so I'm going to turn that over to Ms. Sorek to give us a brief update.
So the first item is the website update, and I will hand it over to Mr. Glass-Steagall for the website update.
Good afternoon, board members. Agenda item 18 is the website update. All documentation is provided in your meeting materials, with the top five web pages viewed between October 31st and January. That's a typo. October 31st, 2018 and January 17th, 2019. I apologize. And also the viewings for the pages that we show continuously, as well as changes over time, including journals, the regulatory advisories to date since they've been on the website, and also an update on the website user friendliness review that is currently in process.
And to give you additional information on the website user friendliness review, we currently now have dates for both of the focus group meetings. So the Northern and Central California focus group for the website user friendliness meeting is Monday, March 11th. And then for Southern California, it'll be held at the Chicago School of Professional Psychology, much thanks to their campus. And that will be on Monday, February 25th. And so in both groups, we have a variety of participants that'll be looking at our user friendliness of our website and hopefully make that a little better over time. And then eventually, as we also get mobile friendly, that'll help everyone to get the information they need and increase our viewership and outreach. That's it. Sorry.
Cool.
Available for questions. Like me to continue to 18B. 18B is the social media update. It gives the likes, followers, following, tweets, and views for board meeting webcasts, as well as changes over time. And I'm available for any questions.
I'd like to make the comment that the most popular post for Facebook was Dr. Harbsheets, and I got appointed. Just throwing that out there.
You just say it.
The next item is the winter journal. Included in the back of the room are hard copies, and included in your meeting materials is a soft copy of the latest journal. The current journal is under review. Dr. Phillips is reviewing that for the spring journal, and then it'll go to Ms. Marks and the Department of Consumer Affairs to package up and get in a PDF format. So moving forward with that. Any questions on the journal? And I look forward to Dr. Kasuga's enlightening EPPP update in the summer journal. Next item, 18D, is the outreach activities update. We did update it to reflect that we had the legislative visits yesterday, which it sounded like in recapping with the members and staff that those were fruitful discussions. We had also, not reflected in here, but Dr. Phillips attended the LACPA convention. And then also that we will have our website focus groups happening in Northern and Southern California. Those are the future outreach that will occur, that will be captured for the fiscal year. We also have a request for myself and Dr. Phillips to attend the mid-year meeting in Santa Fe. So that is also a future request. So any questions about the outreach activities? Okay. DCA brochure. Actually, today during this meeting, I just got the changes that were made from the Medical Board of California to our Therapy Never Includes Sexual Behavior brochure. They were very minor. There was a parentheses with just notating that a psychiatrist is a physician and surgeon, and that's just to better reflect the license type. The brochure will move on to the Board of Behavioral Sciences next, where it will be considered at their March 1st meeting. So then it will be sent to DCA if there aren't any substantive changes to go ahead and package up and get ready for publication. Any questions from the board? Okay. And that concludes the outreach update.
Thank you. Thank you. So we're now going to move to agenda number item number 19, which is the Enforcement Committee report. I did want to mention parenthetically for people that are watching or for people here that aren't aware of it, since our last board meeting, the Enforcement Committee has not met. We'll be meeting in March. And as a result, we have not yet come to more specifics as it relates to the shareholder or stakeholder meeting that we had related to child custody evaluations. So we will be reporting back to you on that at the next board meeting. And I'm afraid that we'd given the misimpression, perhaps, to some people that we had that we were going to be meeting between these two board meetings, but that was not the original intention, nor were we able to do so. Okay, Ms. Monterrubio.
Thank you. So in December of 2018, we had 2 enforcement analysts leave the Board of Psychology. One retired and one received a promotion and went to another board within the department. So over the last few weeks, we have been interviewing, and we did make a job offer to one very qualified individual who will be starting with us on February the 20th. So we're very excited. And we're still conducting interviews to fill the second position. Enforcement analysts, as many of you know, are responsible for performing desk investigations and working closely with the Office of the Attorney General on stipulated settlements, and working closely with the Division of Investigation as well. Since July 1st, we have received 638 complaints. And as many of you know, we can accept complaints over the phone through Breeze, the online service, as well as in writing. And all of the complaints are opened and assigned within 5 days. Since July 1st, we have issued 40 enforcement citations, and cite and fines are issued for some probation violations as well, such as missing a quarterly report, possibly missing a test, not paying cost recovery on time. The more egregious violations, of course, will be referred to the Office of the Attorney General for further discipline. And since July 1st, we have referred 27 cases to the Office of the Attorney General. We are currently monitoring 41 active probationers and 23 told probationers. Again, active monitoring means that they're meeting with our probation monitor at the intake meeting, talking about how to comply with the order, answering questions for their probationers, auditing their files, and again, of the total, we have 23 that are in a told status. And of the 41 probationers, 9 do have probation violations. And if a probationer is out of compliance, they may be issued again a cite and fine if it's minor, or referred back to the Attorney General's office for formal discipline. That is the end of my report. What I have attached to is the overview of enforcement activities. So if you have any questions, I will be happy to answer. Yes.
I have a question. The 9 out of probation out of 41, is that a high number, average?
I think it's about average. I think a lot of times what can happen too is at that intake meeting, some of our probationers are unclear as to what they are required to comply with. So our probation monitor does go over the entire order with them. But initially when they're starting to get started on probation, there may be a missed call. So no, I don't think it's a high number.
Is there any public comment, not having heard any other board comment? Thank you very much, Ms. Monterrubio.
You're welcome.
The next agenda item we will move to is the licensing report from Ms. Chung.
Good afternoon, board members. Including in the report is our data regarding license and registration by the fiscal year on the memo that you could find. And we have also attached the application workload reports for your reference. If you have any questions regarding that, feel free to ask any questions. And then at the end of the report, we also attach the exam statistics for the 2 exams. So if you have any questions, feel free to ask me. Yes.
I say this all the time, but especially for our new members, I just can't say enough how much the licensing staff does. We have by far, the most number of licensees and license applicants of any jurisdiction in the United States and Canada. And I mean by far, we're twice as many as the next nearest jurisdiction. And for them to go through this, I mean, what they go through in a month, many jurisdictions don't even have that many licensees, period. So, I mean, y'all just do a great job. And the fact that you're not backlogged, that this happens so quickly and you're so efficient. I mean, it's just amazing. So, thank you.
Thank you.
Thank you very much for that report, Ms. Chung. We're going to now move on to the continuing education renewals report. And Ms. Burns will be subbing for Ms. McCarker.
Okay. Continuing education audits are now completed through December 2016, and the next round of audits for January, February, March, April, May, and June of 2017 have been sent out, and we have already received almost half responses, so that's great. The deadline for those is March of 2019, so they have their 60 days, of course, to provide their CE documentation. When we looked at the audit pass rate, we talked about that in licensing committee, and we started providing a little more clarification, although I think in speaking with some of the board members, maybe that percentage upheld should be a percentage of the whole. So not the 17 versus 17%, but 100% were upheld, that kind of a clarification in the data in attachment 1. But that way we can also kind of start looking a little deeper into some of the data that we're providing on CE audits and the failure and the reasons why. So we'll be looking into that. Aside from that, the reasons for not passing, they haven't changed much since we were just sending out the next round of CE audits. But when we look at the renewals applications, you can see that we have quite a heavy workload of renewals. And thank you, Sarah, for all your wonderful work, or Ms. Petro, for all the work at the office to process these renewals on a daily basis. We have quite a few, and we're very happy to show that we are continuing the increase in online renewals versus paper. So that is continuing to drive down the timeline for how long people have to wait to get their license renewed, and then also helping the environment and the amount of paper in the office. So also very positive. And if you have any questions or concerns.
Well, again, what I just said about licensing staff, it applies to CE and all this kind of stuff, because again, it's overwhelming, the number. So thank you very much, y'all. I just have a question about when we say percent or number of citations upheld, what does that mean? What does upheld mean specifically?
Absolutely. So I'll back up for a hot second and give a little bit of information. So anytime a citation is issued, that licensee has the option for an informal conference to appeal that citation, and also a formal hearing with the Office of Administrative Hearings and an administrative law judge. So they have both of those options available to them. They have differing deadlines for when they must be requested. So the percentages upheld would be those that were not overturned or revised during the informal conference, where any mitigating evidence that might have been involved in that citation is presented to the executive officer or the assistant executive officer and taken into consideration. Some of those things can include being hospitalized. So maybe you failed to respond to the CE audit because you were in the hospital. And of course, we wouldn't know that until after the fact, and so that's when it's considered. That might be taken away at that point. So those are different things, but that's one clear, easy to understand example of why.
Thanks so much.
In regards to renewals, what are we doing to get the message out to licensees that when you renew with Breeze, it happens right away? When you send in a check, they think, from what I've heard, that, oh, well, I have evidence that I've done this because I have my canceled check, but that it takes a significant amount of time. And people don't, from what I've heard, people don't seem to get that. So what are we doing?
So right now, we not only do articles in the newsletter often, but we also educate licensees when they call. So I would suggest that quite a bit of that uptick is from those that try to renew late, or right up until their deadline and don't realize that it can take up to 4 to 6 weeks for a paper renewal to be processed. As that paper renewal, usually it's the automated coupon that people send back that doesn't come to the board. It goes to an automated processing center that will process that coupon and their check. It could take a couple weeks before it ever sees the board, at which point any deficiency, incorrectly checked conviction box, you didn't certify an FCE, you didn't tell us whether or not you met the law and ethics requirement, that doesn't even come to the board for a couple of weeks. At which point, the protections in the Business and Professions Code that says that you can continue to practice legally past your expiration date as long as you have met the criteria in Business and Professions Code 221, I want to say. 121. It doesn't apply to you then, because you have, we're not just waiting for the evidence of your renewal. You've actually not met the criteria, you know what I mean? So there's that problem. And so oftentimes we communicate with licensees on the phone. They're concerned, they're up against there. We get them on the phone and we walk them to Breeze quickly. Like, this is the way you can renew right now. This is how you can do it expeditiously. We talk about the 4 to 6 weeks. All of my staff will communicate that on the phone. It takes longer, and it goes back and forth. Paper checks have to go down to cashiering, and then they get cashier. I mean, everything extends it out as where your Breeze transaction, as long as there's no deficiencies within 24 hours, it can be renewed. So we do it here. We talk about it in the newsletter. It's also on the renewal itself, if you're reading all of the language on the renewal. But I think hopefully that word's getting out quickly. I would assume it is for a variety of reasons, along with those that call at last minute to
Right.
renew.
I'm
We've had a
wondering-
continued update in that, right?
Hmm?
I mean, we've had more and more people every time
Absolutely.
start renewing online.
I'm just wondering if, like, maybe in the summer journal, we could do a box that has a flow chart that shows if you renew online through Breeze, you're renewed. You know,
Are you volunteering, Dr. Harpsheets?
oh,
Sounds like a
But I'd have to
fantastic
call-
article.
I'll call Miss Burns too to get. But I'm happy to do it. I think that visual might really get people's attention, providing they've met all the requirements. This is the timeline, and to show that if you send it in online, it doesn't come directly to the board. It might be addressed to the board, but it doesn't come directly to the board. I don't
Be a
think people.
great article. I'm
Yeah.
excited to read it.
And I will, Dr. Harpsheets, I will work with you on
Good. Thank you so much. Thank you.
I'm always happy to be of service.
Okay, go on. And I was going to say, you presented this information in orientation, and I am just astounded that 82% of people, the CE audit, I'm not getting it. That's in my head. That should be like 98%. I'm not. I'm sure everyone on the board has an answer, but it's just fascinating that percentage rate is not a lot higher because it's not a shock and it's not a surprise and it's, it happens. That is astounding to me.
Can I just say that we've been looking at that in the licensing committee meeting, really trying to see where the problems are and where the difficulties are. And that's been kind of an ongoing. So first we wanted to get a sense of what the process is, but I think we're continuing to look at this because we agree with you.
That's astounding.
It's astounding. Yeah.
And I would just tell you, as is any process, there is a range and a bell curve of anywhere from oopsie mistakes, incidental things, thought they counted, didn't count, not understanding the requirements quite correctly or how they might apply that way, up to just blatant didn't do them.
Or double dipping
There can be the confusion of double dipping. Some people that have failed an audit before did not read all of their order properly, and you wanted to use those hours again, and we second audit to make sure they don't, and they did. Other times it was they did not look at the approving agency, they didn't understand that process. Other times I'm not sure how they didn't know it was 36 hours, but they went for 27. They thought 27 was the number. And so I'm just being honest here. So there's a wide variety of reasons. We definitely want to work on educating our licensees to remind them of the 36 hours and 9 non-independent learning hours. So
I think you mentioned.
I actually am going to call on Dr. Kasuga. She's been waiting to speak.
Oh, she has. Oh, sorry.
I just I have a question with regards to strategic planning. For the sake of transparency, we talked about implementing that licensed board members get audited on every renewal cycle. And I'm just wondering, when will that start? And is that going to be right away? Because I'm renewing soon as well.
I would tell you that staff has action planning for the strategic plan after the board's approval of the strategic plan, at which point we would talk about implementation timelines.
Okay. But I
So
have
I
all
wouldn't
my
know
hours
Marty.
already, so.
You're ready to go, huh? All right.
Dr. Harpsheets?
Yeah, I think that's a key that you, I think, mentioned in the licensing committee, that people are sending in, they think they're doing well by sending in their renewal or doing it on Breeze, but they think, well, I have until the 31st of that month but to complete all the CE. And that's coming up. Is that correct?
Absolutely. So that usually ends up in an educational letter. So if you had all 36 hours, but say you renewed on the 17th, but you expired on the 31st, and so 6 of those hours were accrued on the 22nd, we would send you an educational letter to let you know that, again, when you renew, you're certifying under penalty of perjury that you have completed those hours the day you signed that renewal. Not that you've accrued them by the time you expire, but that day you signed it, certifying those 36 hours, that's when you're certifying it. And so we send educational letters for that. And I think that word has actually gotten out as well, because we do see a little less of that than we used to see a couple years ago.
One other thing I'd like to highlight relative to this whole renewal audit process, people that fail an audit are going to be audited the next time they renew. And somehow the statistic as to how many of them don't pass the second audit is startling. And we tell them specifically when they fail the first audit, you're going to be audited again. So it is quite a remarkable phenomenon, which I know, again, the licensing committee is taking a look at, because some of this seems so at odds with being a licensed psychologist. So it's a little hard to understand what people's thought process is or how this comes to pass. So it'll be interesting to hear more about it.
Really quick, one other item from the strategic plan that I'm really excited about, and I think staff is tired of hearing about, but we are going paper light with our processes, and it's a really big deal. Renewals, our goal is that by 2020, that will be all online. Now that will be two ways. You'll either go through Breeze and renew online, or you will download the renewal application on the website, submit a check, and then submit that to the board. We are going to stop, as of 2020, sending that renewal coupon that people are submitting that's getting caught up in this 4 to 6 week system. And it just doesn't make sense that we have 3 ways for people to renew. When it really should just be 2. Either you do a paper process with a check or you do it online. So that's the goal. And I just want to highlight that. And as much as we can start kind of talking about that at our board meetings and in our discussions that we're going paper light, I think the more people will be aware that it's coming.
Yes, ma'am.
And I just feel compelled to say this because I do think Paperlight is great. And then I also realize the connectivity with paper is important. So I appreciate that we're moving Paperlight, but I also then, as it's been said a couple of times over this last meeting, over the last 2 days, about ensuring people understand. And I think that we are educated people, we read, but then we also don't. We miss things sometimes. And so I also feel like as we move to this Paperlight piece that, if we then dedicate some time to pick up the phone and people don't get a voicemail, just because I feel like the relationship that we have to educate people is important. So it's a balancing act, and I know it's probably not appropriate at this point, but when you mention the Paperlight, I feel like the other side is, as a person who is not new to the work world, I think that there is a generational gap in how we deal with technology. So I hope that we don't lose the touch of educating people and not relying solely on being able the written word through technology, that we do have an opportunity to connect with somebody. So a little off topic, President Phillips, but I just feel like it's important to say. And I think it's admirable, and I should not say but, and I think it's admirable for the green technology that we're going Paperlight, but I just feel like we should keep that in mind too.
I appreciate that point exactly, because staff resources will be necessary for this kind of a transition where we might need additional phone time, more people to help with that process as we walk them through that.
Is there any public comment on the continuing education and renewals report? Hearing none, we are now going to take a 10-minute break. Okay, we're going back on the record and after a break, and we are now going to go to item number 20, return to item number 22, the licensing committee report.
Okay.
Dr. Horn?
Thank you. If we can if y'all can turn your attention to item 22A, the licensing committee had a report from two organizations at the last licensing committee meeting. And if y'all remember, just to set the stage, we had learned that there was a lot of variability in how foreign trained individuals who were educated outside of the United States or Canada, how their credentials might be reviewed for us to determine that they were adequate, that their educations were adequate for licensure, for our licensure requirements. And so we had asked two organizations that do this kind of, right now in our regulations, we talk about only one of these organizations, the National Association of Credential Evaluation Services, NACES, and we required that for international students who were educated outside the United States or Canada to have their educational credentials verified. I think the National Register of Health Service Psychologists actually requested that they present as well to us, because they also perform this credentials evaluation service for internationally trained applicants for licensure. So we had them talk to the licensing committee meeting at last month, and had a discussion with these two representatives about what they do and how they evaluate credentials and all this kind of stuff. And as a result of that, we asked staff to use the discussion that we had to draft amendments to the Business and Professions Code, Section 2914, for us to review and discuss at the next meeting. So basically, we have asked them, again, based on our discussion, which was, pretty substantial. So basically, that's all I can tell you at this point in time. But to come up with some language that then we can consider and the board can consider about these evaluations. We just want to make sure that our applicants are really getting a good evaluation that will tell us, the board, what we need to know to assure that their credentials are valid. So,
I have a question.
Mm-hmm.
So the NACES is the one that right now we accept, and so we don't accept the other one at this time?
Not at this time.
Thank you.
One of the things I think that the National Register kind of told to us is that they are psychologists who do the evaluation, and they only do evaluating the credentials of psychologists. So they felt they had a particular expertise in this, and so we wanted to include them. So, but anyway, we'll have more. Our next licensing committee is June, so we'll have more to bring back to our August meeting about that then. So that's informational only. If we go to 22B, it's just to let you know that we are going to be updating or creating an informational video for supervisors. And we are going to consult with folks in the state who've offered, who are experts in supervision, who've done a lot with supervision, and we want to make sure that we are providing, just like we said here, information about the regulations for supervisors, for the best practices in terms of supervisors, and also provide a list of kind of frequently asked questions. That'll be on our website, so that if anybody has any questions about supervision, how they should do it, or even what their supervisor should be doing, we want to actually have a way to outreach to folks to provide that information. So that's coming up. Yeah.
Sorry, Dr. Horn. I think to just go back to 22A, we did receive a public comment letter.
Oh, I'm sorry. Thanks so much, Mr. Fu. We did receive a public comment that was in your hand carry package from somebody who was in support of us using the National Register. And so I just allowing that to also be one of the credential evaluators. So I just wanted to let y'all know that we have had that public comment. Thanks so much, Mr. Fu, for reminding me of that. And so then back to foreign credentials. So that's it. And then back to the, that's okay, informational video for supervisors. It's just information. We're moving ahead with it. So
Thank you very much. Okay.
That's it.
So item number 23, which we had not completed, was the legislative update.
So on Wednesday, February 6th, we had meetings with the chairs and vice chairs of the business and professions committees in both the Assembly and the Senate, as well as new members. And the folks who are making these visits included Dr. Kasuga, Dr. Tate, Dr. Harb Sheets, and Dr. Phillips, as well as Ms. Burns, Mr. Thomas, Ms. Monterrubio, Mr. Glass-Spiegel, Ms. Sorick, and Ms. Chung, as well as myself. And so we had 11 meetings in total that afternoon, this Wednesday afternoon. And I'll just make some brief comments and we can have folks chime in as well. But the main thrust of the comments was really to introduce ourselves, particularly to the new members, what the role of the Board of Psychology is. But we also gave them some previews related to some potential bills that would be coming before them, including the recent action today to formally seek an author for amendments to the law regarding sexual misconduct and expanding that definition. There was also a discussion about the omnibus bill, which are making non-substantive changes related to the exam, and then something that's more substantive, which is the creation of the voluntary surrender status, so that our licensees with have a graceful exit from the profession if there's a cognitive capacity issue. And then also thinking through the 2020 Sunset Review and giving a preview of that perspective as well. We did also briefly talk about 2138 and AB 2138 passed last year and some of the potential implementation challenges with a July 2020 deadline, just given the length of time it may take to go through the regulatory review process and how urgently we are acting as evidenced by today's action by the board. And so anybody else want to chime in on their legislative visits?
Well, it was. I will say that as being one of the people that had gone, and we had great board member participation this time, for which we're very thankful. That it was a really positive experience by and large. I think. In fact, I can't think of anything that was particularly negative about it. The officers were very receptive, and we were very grateful for them to take time out of their busy schedules in order for them to meet with us, and so it's pretty cool.
I would just add that the conversations and the ones we went to were very engaging, that this person we met with asked questions that really indicated they were interested, they were listening, they wanted to really understand our role and how that affects consumers. So I found that really encouraging.
I would agree. This is my first time to do the legislative visits, and that was the same thing with our group. We found the members engaging and asking questions about the things that we do, and it's a good way for us to talk more about what we do as a board and the things that we've accomplished as well.
which is pretty good to kind of like share those accomplishments from last year, as well as what we plan to do in this year.
And I'll just add one more comment, and that is, given the level of divisiveness that we see in the national political scene, I was really impressed by kind of the receptivity of people of various political stripes to what we were talking about, and their willingness to work with each other around it. So it was kind of a reaffirming experience.
Okay.
I would just have to echo. First time doing it, and I was with very experienced people, Ms. Burns and Dr. Kasuga, and everyone was receptive. They asked interesting questions. Some visits were short, but others were lengthy, and they wanted to take the time and talk with us, and I appreciate that.
Ms. Burns?
And I would just say it's always a good thing to keep in contact with the business and professions committees in both houses. It's a great check-in. We heard great feedback from the committee staff as well on those things, and some receptivity that with the good work we're doing to try to implement AB 2138, that they are recognizing that, and that they are following along in case there are challenges with that 2020 deadline. So
I would be remiss if I didn't call your attention to the hand carry items, which include the legislative summaries, the legislative proposals, and the quick facts. So you have a copy of those items. Is there any additional board discussion? Any staff or public comment related to this? Dr. Schaefer?
Oh, my apologies. Yeah, please. So is there any public comment on the agenda item we're on right now? And then we'll invite you forward, Dr.
All right, seeing and hearing no public comment on the legislative visit summary, I turn it back to Dr. Horn.
To call forward.
Dr. Schaefer,
Slower,
come on down. I'm telling you, if we do it out of order, I'm just kind of do it.
Is this on? Can you hear? Oh, okay. They're always on. Just an offer that if it's at all helpful, the second Saturday in March, Division 2 is having a convention or conference on supervision, and we have heads of supervision at various institutions attending. We kind of max out at 100. If there was something you thought would be helpful, like a short questionnaire or ask some paper handout where they could give feedback on what they'd like to have in a video, we could do that. And at KPIC, we have 90 sites throughout the state. They're mostly community mental health sites, and we could easily send out something if you give it to us on email and then get you some feedback if you were so inclined.
Thanks. That's March 19th, did you say? Did I make
I don't
that
have is it the 15th, the second Saturday?
Oh, second Saturday.
Second Saturday. And one of the board members is coming, right? The 16th.
Who's coming?
Actually, we got the information about the supervision conference, and I thought it would be a good idea to send our new licensing coordinator, Mai, to get exposed to the information that's provided about supervision, especially because she's going to be working with Ms. Chung on the Pathways package. So Dr. Schaefer has graciously invited us to give a little 5-minute opener just to speak to the group, because we're going to have a lot of captive audience. So I thought that would be great just to say thank you for having us, discuss kind of where we are with Pathways or what that process looks like, and then we'll be there just to listen and take in the information for the rest of the day.
I've graciously offered to check with my board, but I'll be surprised if they don't say yes. So, I have no power, so I will let you know. I'll text you or email you.
So maybe part of what y'all could do when you go to is ask your group who's there, just ask them while they're there and get some,
yes,
any kind of feedback that y'all
And
might
with
have.
KPIC, because it's,
Right.
it's just a quick email that goes to all, it can even go to all our academic programs throughout the state. And, there's a lot of those, but 25 and same thing. Okay,
Thanks.
you want to send me something and then we'll send it out, or do you want us to just generate
We'll
our own?
talk. We'll talk.
Okay, great. Thank you so much.
Thanks.
You have more on 23? Okay, please. We will return to Mr. Fu.
Real quickly, not to belabor the point, item 23B2, this is what we referenced when I talked about the legislative summary about our visits. This is in relation to the legislative proposals that staff have submitted to the BMP committees related to the statutory cleanup provisions for examinations, and then secondly, approved newly proposed language in relation to the creation of the voluntary surrender. That language was approved by the board in November 2018.
Does that conclude your report?
Can I ask a question about y'all's visits? I'm just curious if in your visits, if there was any particular thing that we talked about that you felt got most interest from the
I can only speak
places.
to my experience of it. I thought 2960.1 was probably ended up usually being the most substantive discussion, to the extent that we had more time to visit with people, which would be the language about sexual behavior in addition to sexual contact. So in our visits, the visits I was involved in, I think that was, and voluntary surrender, I think they were interested in the fact that we were creating a voluntary surrender status, but yeah.
I thought that they were particularly interested in that. Also, that we had the booklet, and they had copies of the booklet in their packets, and we told them a little bit about how does this play out. Who gets this booklet? Is it just sitting around? But in practice, how? And I thought they were fascinated by how this really gets disseminated in a clinical setting, and I think that engaged them. Would you say so, Mr. Fu?
Yes, absolutely.
We were told that one of the members had a pamphlet on their table and that they really read through it.
It's the pamphlet we gave them last year.
Yeah, so we told them that, guess what? We updated the pamphlet and we'll make sure that you're going to have the updated version soon.
That's interesting.
Any other board comment, reflections, public comment?
Let's not do reflection.
I do want to acknowledge and thank staff for preparing us for our legislative visits. And I think it was so much more pleasurable to have, first of all, know where we're going, to have someone who has that schedule, but also when it came to the specifics of what we're talking about, to have staff they're so really on top of it to provide additional detail. I know in our group we had Ms. Monterrubio and Mr. Glassspiegel, and I'm sure with the others as well. It was just so helpful to have that added on the ground lens to what we do. So really thank you. And as a person who does have to do legislative visits and arrange them, I know how hard it is to arrange 11 visits. So thank you to staff for that. For doing that. We really appreciate it.
Okay, we are going to now go on to a very brief report on item number 25. We've already spoken to 25D. Mr. Glassspiegel?
Yes, thank you. Good afternoon again, board members. Attached in your meeting materials is agenda item 25, which is the regulatory update. In this update, it lists the status of the 5 regulatory packages that the board staff is currently working on and the status of the packages. Everything is current. The only updates are the standards of practice for telehealth. That package has returned back from legal on the 31st of January, and I have been working to incorporate the changes in anticipation of resubmitting it back to legal counsels for their review. And the update is then, and also now we've finished voting on CPD, so I can get that package moving again. That's the end of my report.
Great. Thank you very much. I know it's a lot of work wrangling those packages. So, item number 27 is recommendations for agenda items for future board meetings. They're not for comment by board members, but simply to put them on future agendas. Does anybody, board member, have any agenda items they would like to add other than what we've already discussed in the meeting? Any member of the public? Apparently not. I would like to add, and I think we've all said, oh, did you want to say something? Okay. Well, I was just going to say, it's been acknowledged by several board members today what a wonderful staff we have and how hardworking they are and how much support they give us as board members and how much we appreciate it. So I would just like to say a shout out to all the staff that we're really very grateful for your service to the state and to the consumers of psychological services in California. So thanks. 2 thumbs up.
Can I add to that? As a new board member, it's amazing to see how well the staff works together, how available you are, and to hear how not only do you consider the safety of our consumers, but that with an understanding of what it means for licensees too. I think you do a great job of balancing that, recognizing still the priority of consumers. Thank you.
Ms. Jones?
Yeah, and ditto. I was trying to formalize in my mind how I wanted to put this as a recommendation for an agenda item, but I'll do it a backwards way. I will just say it's been a pleasure meeting the 2 new board members, so it's been exciting to have a full complement of a board staff, but also I know that there's lots of interest in writing over here, so you're already given her an assignment for the newsletter, because we've had that conversation offline. So I'm glad it came up here. But also, given the notion about telehealth, Dr. Tate in the Reading area, I feel like it would be really great to. We've had before a discussion about doing stuff in LA about the prison system, the LA County system. It would be great to do something about rural health, and I know that you already have the composition of the telehealth committee, but it seems like you could offer a lot to that committee. And I do know that it's been a while. I think when I first joined, we had someone from that area, John, and I can't remember the doctor's last name, but he was from a rural.
Preston.
Thank you, Dr. Preston. And I know that, it's been a while since we've had that voice on the board. So I don't know what that looks like in terms of an agenda item, but I definitely am excited to work with the 2 of you. But I know that that's a voice we haven't heard, and I'm sure you can add to that. So it's a open-ended kind of agenda item. And again, more importantly, I'm excited also to work with the staff, but the 2 new board members, welcome. And it's exciting to have the 2 of you here.
Okay. With all of that in mind, and adding that to perhaps a future agenda, I would like to adjourn this meeting. Would anybody like to make a motion for adjournment? Okay, it's adjourned. We don't have to vote.